Good morning and welcome to another episode of The Future of Europe. I am MH17 and I will be your host today. And I'm happy to welcome Bertille Grandière as our special guest from the Master's degree of European Law and Litigation at the Catholic University of Lille.
Thank you for having me.
So today we'll talk about the tragically famous MH17 flight and how it came before the CJEU. So Bertille, could you please enlighten us on which specific context that this case concerning flight MH17 takes place?
Malaysia Airlines flight MH17 was shut down on July 17, 2014 over eastern Ukraine in a conflict zone, killing all 298 passengers and crew on board. The Dutch Safety Board investigation concluded that a Buk 9M38 missile was fired from an area following Russia controlled by pro-Russian separatists, with evidence pointing to Russian military involvement. The incidents occurred within the border context of the Donbass war, which began in 2014 following Russia's annexion of Crimea. The ongoing conflict between Ukrainian forces and pro-Russian separatists created an unstable airspace over eastern Ukraine. The crash intensified geopolitical tensions between Russia and Western countries, lending to the opposition of stricter international sanctions against Russia. And legal proceedings were initiated against Russia before the European Court of Human Rights and national courts, particularly in the Netherlands, where a criminal trial sought accountability for the tragedy.
Thank you for this context. So regarding the Netherlands, what are the main facts to know about the Dutch media affair?
Two Dutch media outlets, RTL Nederland BV and RTL News BV, sought access to European aviation safety reports concerning the MH17 crash. On January 10, 2018, they submitted an information request under the Dutch Administrative Transparency Act, requesting access to European Coordination Center for Accident and Incident Reporting System data related to the crash. The Dutch Minister of Justice and Security initially forwarded the request of the Minister of Infrastructure and Water Management, responsible for aviation safety data. On April 17, 2018, the request was denied based on confidentiality protection under Regulation number 3076, which 2024, which aims to safeguard individual reporting aviation incidents. The Dutch District Court upheld the rejection in 2019, and the case was subsequently escalated to the Dutch Council of States, which refer a primary creation of the CJEU. The case represents a conflict between freedom of information, Article 11 of the Charter of Fundamental Rights of the EU, essential for democratic oversight and public accountability, and confidentiality of aviation incident report, Article 15 of the Regulation 376/2014, which protects sensitive information to encourage open reporting and prevents potential relation against whistleblower. The CJEU reaffirmed the principle of proportionality, stating that confidential is not absolute. The government must assess each case individually concerning the sensitivity of information, the public interest, and the necessity of transparency. In the case of a major public concern, transparency may outweigh confidential restrictions.
Okay, thank you very much. And in concrete terms, how does this case help to understand the EU's perspective on complex situations compared to any other legal organizations?
The European Court of Human Rights accepts the Netherlands complaints against Russia, focusing on Russia's direct involvement in the MH17 crash and the failure to conduct a credible investigation. The ECHR emphasizes state accountability and the protection of human rights for the victims and their families. The Court of European Union On the other hand, maintain a strictly legal perspective focusing on the balance between transparency and confidentiality in aviation safety, rather than addressing the geopolitical conflict or attributing responsibility for the crash. The CGEU reinforced in this case law on fundamental rights, particularly in relation to proportionality, ensuring that restrictions on trials serve a legitimate objective and do not exceed what is necessary, and necessity and justification, emphasizing that limitation or transparency must be justified by concrete rather than general concern about confidentiality. Similar precedents exist in Digital Rights Ireland or Sky Ostrich, where the CGEU assists limitation on fundamental rights in the context of public concern.
Okay, and I was wondering what challenges would you say could be raised from this case for the future of the European Union?
First, reconciling fundamental rights with public security. The EU faced the ongoing challenge of balancing the right of information with the need to protect sensitive data in aviation safety and other security-related fields. There is also another challenge, the role of the media in the democratic society. This case underscores the importance of media access to information to maintain public trust and democracy oversight, particularly in matters of global significance. In addition, legal harmonization with the EU, ensuring consistency between national and EU law remains a priority. The Dutch restrictions on information access conflict with the EU legal principles, highlighting the need for better alignment amongst member states. Also, EU-Russia relations and geopolitical stability. The MH17 case contributes to the deterioration of EU-Russia relations. The EU's collective response to Russia's aggression in Ukraine, including economic and diplomatic sanctions, demonstrate that the bloc's commitment to upholding international law and human rights. Finally, long-term legal implication. The CGEU's ruling in the case may set a precedent for future cases involving the conflict between transparency and confidentiality, influencing how information access law are interpreted across the EU.
Well, thank you very much, Bertille, for your time and your answers, and thank you for everyone who has been watching this episode on the future of Europe.